What's up, everybody? Happy Good Friday is when I am recording this. I think you're going to be listening to it on a Saturday, but we have the judge's orders. Judge Cannone has entered her orders, and some of them are very surprising. So we're going to go through them today, see how they'll affect trial number 2, and also a brand new motion filed by the Commonwealth that really makes you shake your head. And I hope what they're doing is asking for the world, hoping to only get a little piece of it, because I, again, can't imagine how a prosecutor would expect to actually win the motion that they filed. So we're going to look at all that today and answer a lot of your questions throughout. Thanks for being here. Hit that like button. Let's get started. So the first thing we're going to look at here is the miscellaneous orders. Okay, so these are the rulings on all the motions that we looked at on April 16th. The defendant's motion for reconsideration of portion of February 18th order denying defendant's motion to compel production of forensically sound copy of January 29, 2022 Sally Port footage, paper number 532, allowed in part, denied in part. The Commonwealth has agreed to the motion insofar as it seeks to have a defense expert download a protected file pertaining to this case from the Canton PD. To the extent that the motion seeks an order permitting the defense to forensically image the entire Canton police detective file, it is denied. Commonwealth's renewed motion to exclude testimony of Garrett Wing, which is an additional expert the defense wants to call, who's not a medical doctor, to deal with the injuries and dog bites and things like that. After reviewing of the expert witness report by Lieutenant Garrett Wing, I find that he appears to be qualified by experience to provide help to the jury on some issues in dispute. If the Commonwealth still asserts that Wing lacks the qualifications necessary to provide expert opinion, it should renew its motion prior to Wing taking the witness stand, if indeed the court will conduct a limited voir dire at that time. So, listen, that might surprise some. To me, this is kind of showing Judge Cannone's consistency. Regardless of her verbiage and who she likes more, basically one side or the other, or who she's kinder to in her motions or has better language to, which I think she should ascribe to be even-handed even in that, she has basically let every single expert witness testify. And this could have been one that she struck, but she didn't. She's going to allow him to testify. The Commonwealth's probably not happy about it. I think that is very important for the defense. I think that is huge for the defense to be able to stack up all these experts and all these witnesses. There's going to be a lot more, because most jurors are like, okay, defense, when the state rests, they're like, okay, defense, what do you got for me? And in a lot of cases, the defense has little to nothing to present because they don't have a burden. But for the jurors that expect something, this defense team is going to give them something. The defendant's motion for reconsideration of March 16, 2025 order denying the motion to exclude James Crosby. Dr. Crosby is clearly qualified as an expert. So if we compare it up to Wing, she's like, it appears he's qualified by experience. Here, Dr. Crosby is clearly qualified. Well, guess what, folks? We can complain about that if we want. I know I've complained about some of her language in the motions, but guess what? Clearly qualified and just barely qualified from her perspective is enough. They both get to testify in front of the jury, and the jury gets to make the determination as to who they think is more qualified or the better expert or who they should listen to more in this case. But he's clearly qualified as an expert, but he is precluded from testifying that his bite mark analysis excludes Chloe as the cause of the marks on the victim's arm. So anybody who says she's just giving Brennan whatever he wants, that's not true. She is not. She is trying to be even-handed. She fails sometimes, but I do think she's at least trying to be even-handed, and some of these orders prove that. Because she could have been like, sure, go for it. But she didn't. It would have been wild and crazy, but that's how a lot of people are expecting her to act. So I'm glad that she's not. And hopefully she's going to be consistent throughout the trial and do what's right. Allow him to get into the third-party culprit stuff. Allow the defense to present a defense. It's Karen Reed's right. And she should get to do that. But I'm glad she made the right decision here. He's going to be able to testify to a lot of things, but not specifically to exclude Chloe based on the measurements and the bite mark analysis, because it's just not scientifically reliable. He is not precluded from testifying as to, I think she means, the anatomy of a canine mouth, or of Chloe in particular, including the measurements of her mouth. To the extent there is a question as to what the testimony of the Commonwealth may elicit from Dr. Crosby to rebut any defense expert, it can be raised at trial. So that's a part I disagree with. How are we going to get into Chloe's mouth specifically in the measurements? If he says the measurements, if I was the defense, by the way, here's what I would do. I would say, Judge, absolutely not. He can't. By giving the measurements of Chloe's mouth today, which is not the day that she actually bit John O'Keefe, or that we are alleging she bit John O'Keefe as the defense, a juror knows what 6 inches is. A juror knows what 12 inches is. They know what 2 inches is and what it looks like. So to say it's 4 inches, they're going to look at John O'Keefe's arm themselves and be like, is that 4 inches? It doesn't look like 4 inches. Where do I start? Where do I end? It's going to confuse the jury. It's going to give them information that's going to create confusion, which is the exact opposite of what we want to do as lawyers. If you're not going to let him testify to her exclusion, he shouldn't be able to put in her measurements. Why is Chloe going to come up that he went out and saw her and measured her if he's not going to exclude her? That's going to be a very obvious question the jury has. It's going to confuse them. That's the opposite of the purpose for an expert. I really think she shouldn't allow that. We'll see what she ends up saying. Next, the Commonwealth's motion to submit to substitute DNA analyst. The defendant did not object. The Commonwealth's motion for notice of any visual aids, potential exhibits, or potential chalks that will be displayed to the jury during opening statements. No objection by the defendant. Defendant's motion and notice that the defendant intends to display visual aids to the jury during opening statements. No objection by the Commonwealth. That's going to become important later in the video. Both sides wants to use visual aids. Both sides should be able to. That's exactly what they do. They help the jury. They help lawyers present their case. All good lawyers should and do use visual demonstrative aids in openings and closings, and even with a lot of witnesses. So if one lawyer objects to that, I always side-eye it. I don't like it. I'm like, you afraid of visual aids? Especially things that we already agree are coming into evidence. And by the way, we've done this trial before. We pretty much know what's going to come into evidence, like 90% of it. Next, the Commonwealth's notice of intention to introduce extrajudicial statements of the defendant. The defendant does not object to the introduction of the defendant's extrajudicial statements to the extent that the defendant objects to the Commonwealth's use of an independent reader for text messages between the defendant and John O'Keefe. The defendant should submit her objection in writing by close of business on April 18th, which is today, Friday, that I'm recording this. So they're basically saying, we know you're going to get in Karen Reed's statements, but you're not going to have some actor go up there and read them. The judge is going to have to figure out exactly how to handle that. We'll wait and see. I personally don't think this is going to be a huge deal, and I hope everybody's going to ethically handle it, whoever reads it. And if not, if there is any emphasis on the wrong syllable, that's a major issue and potentially an appellate issue, a potential motion for a mistrial. If somebody really tries to beef up or juice up some of the things Karen Reed says, John O'Keefe says, whatever, we can't have that in trial. It's a text message. Read it like a text message. Lastly, the defendant's motion for specific discovery. The Commonwealth and the defendant have reached an agreement to all remaining disputed materials except for materials number 3, and 4. Number 3 seeks any information, including any oral or written statements of communication of any witnesses suggesting a reluctance or refusal to testify in connection with this case. Number 4 seeks any information, including any oral or written statements or communication of any witness herein or wherein a witness suggested a reluctance or refusal to cooperate. Though it is a close call, this request is covered by Massachusetts Rule of Criminal Procedure 14B 2B3 and should be provided. It's almost always, and again, at this point, let me tell you, if I'm the defense attorney, and I would be willing to bet this is their feeling. Judge Cannone, call it a close call. Call it, maybe I shouldn't do this, but I'm gonna. Put whatever verbiage you want in there. If you're going to grant our motion, great. We don't care if you say, I wish I didn't have to. It's a close call, or give some help to the Commonwealth. And that's what Cannone did. It's a very close call, so we know exactly where she's going with this. The defense wins. So the Commonwealth has to provide it. Therefore, as to 3 and 4, the motion is allowed. The Commonwealth must provide this information within 1 week. If the witness is scheduled to testify prior to then, the Commonwealth must provide the information at least 1 day prior to the witness being called to testify. So, Hank Brennan, oh, judge, they're providing things in the middle of trial. This is so unfair. I might have to change my whole theory of the case. Well, it looks like he's going to be providing discovery that is within the rules, and he has refused to provide so far. Again, I don't hold that necessarily against him. If you want to fight and you don't think you should have to discover it, and it comes before the judge, and the judge doesn't make a ruling until literally the eve of opening statements, it is what it is, but you have to turn it over. You're going to be turning over discovery during trial. Oh, boy. So all your complaints about the defense doing that, it's going to be tough. And if I'm the defense, I'm marking this one away saying, Judge, guess what? We were right. He was wrong. I don't care if it's a close call or not. We were right. He was wrong. He provided discovery during trial 1 day before a witness testified. Guess what? If there is a delay on ARCA or anybody else, I would say we'll provide it 1 day before they testify, Judge, just like he did to us on witnesses that may have this information. It's important. I promise you, it's important. Because of the accusations and allegations that have been going back and forth, this is important that they were wrong. They should have turned it over and they didn't. Not sanctionable, But the judge is going to fix it by allowing him to turn it over during trial. She'll do the same for the defense. At least she should. All right, let's get to the next order. And this one is on the motion of intervener Aiden Kierney to be exempted from sequestration order. This is Turtle Boy. The Fifth Amendment to the United States Constitution guarantees that a person cannot be compelled by the government to provide incriminating information about himself. During hearing before the court, intervener Aiden Kierney indicated that if called by the Commonwealth to testify at the trial of Karen Reed, he would invoke that right. By the way, she let him do it up at sidebar where nobody was watching or listening, not giving Hank Brennan his aha moment. And frankly, not giving Aiden Kierney his aha moment, because my guess is he would have liked to get up on the witness stand and look Hank Brennan in the eye. He would invoke that right. The court finds that Mr. Kierney does indeed have a valid basis to exercise this constitutional right, meaning there are charges against him that could be potentially incriminating if he makes statements, and nobody's given him immunity. We've seen scenarios, like in the YSL trial, where they're like, guess what, brother? You're getting on the stand and you're testifying. You want to know why? Because you're immune now. And the state has the right to do that. Get rid of all the charges, throw them out, and put Aiden Kierney up there and make him testify. Because now he has no valid Fifth Amendment right. He has no fear of prosecution. There's nothing that he's going to say that's incriminating because he's been granted immunity. I don't remember which witness. I think it was it Woody? I think it was Woody that they forced to testify and grant him immunity. And that's where we had all the, non-party or ex parte meetings and all the problems in the YSL case. But they could do that here. If they wanted to grant him immunity, they really wanted to testify, then do it. You know how to do it. Hank Brennan knows how to do it. Michael Morrissey knows how to do it, and they didn't. So because you didn't do that, he doesn't have to testify. That's how rights work. I also find that witnesses who are the named victims in the pleadings, indictments against Aiden Kierney and the family of John O'Keefe will be permitted to testify before the jury without Kierney in the courtroom. Therefore, his motion is allowed in part and denied in part. So same as last trial, except in addition, John O'Keefe's family, I don't remember if that was in the first trial. So it is hereby ordered that Kierney is exempt from sequestration order except for Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Elizabeth Proctor, Jennifer McCabe, Matthew McCabe, and Yuri Buchanan, and any member of the O'Keefe family. So it may be a little broader, still probably very frustrating for Aiden Kierney. And, they bring these allegations, but the way the statute is written, they obviously have probable cause at this point to go forward on those crimes. So I understand the argument. Don't do things that give them probable cause. I understand the argument, especially that Betterow has. He sets it out the best of the problem with that witness intimidation statute in Massachusetts. I think it's incredibly problematic, but it is the law, and it's the law that is the ruling the judge has to rule under. So I think this is the correct ruling as everything is currently seated with where Aiden Kierney's case is and where Karen Reed's case is. But to just have him out the entire trial would have been crazy. And to force him to do, anything with regards to his Fifth Amendment right would have been crazy too. Okay, now we get to the final document I want to talk about in this video. I don't know if I'll say it's shocking to me, but it's annoying. Commonwealth's motion regarding defense's opening statement. Remember, the prior ruling, using demonstrative aids. Commonwealth has no objection. We know that I believe that, I can't remember specifically if the words were, we only have one picture we want to show. And I guessed in my last video that was going to be the injuries to John O'Keefe's arm, because that's what kind of proves he wasn't hit by a car, right? And they have a lot of good evidence with that. And, my, fake opening statement or whatever, my little outline, I would focus on the horrible investigation and bad cops. And then I would focus on the impossibility that a car hit John O'Keefe. And the way you do that is with the experts, Russell and the ARCA guys, and Wing now, and the pictures. And how this wasn't a car. Could have been an animal. Could have been a fight. But it wasn't a car. Well, the Commonwealth is picking up what the defense is putting down and how that's likely the argument they're going to make, or at least the statement they're going to make in opening. And so they file this motion. The Commonwealth moves for an order that defense counsel refrain from claiming in their opening statement that any of the victim's injuries were caused by any person or animal that was inside the home of 34 Fairview Road. Based on the defense's request to show the abrasions to the victim's arm in opening statement. So I guess we were right in our guess that the one picture they want to show is the injury to John O'Keefe's arm. The Commonwealth notes that the court has ruled the defense is precluded from mentioning any reference to third-party culprit claims prior to establishing a viable basis supported by admissible evidence, and any mention of third-party culprit claims relative to the abrasions would be improper. So here's what I see as the ruling of the judge. You cannot say Brian Albert or Brian Higgins. You cannot say their names. But to limit what the defense can say, as far as this was not a car, to me, would be overreaching by the court. To say that they can't say they didn't go inside that house to see if anybody in there had any fight with John O'Keefe. Do they have any animals that could have caused these marks? You're going to hear the investigation was so bare bones, so lackadaisical, so against police procedure. And that's not argument. That's what the testimony is going to show. They didn't go inside 34 Fairview. They didn't go inside 35 Fairview. They didn't go inside 36 Fairview. All these houses around. Were there animals that could have caused these injuries? Because it wasn't a car, according to our experts. Did anybody get in a fight with John O'Keefe? Hit him with a bat in the back of the head? Anybody see him trip and fall? They didn't go inside any of those houses, including 34 Fairview. That goes straight to the lack of investigation. I get it. You can't say Brian Higgins and bring up all the problems with Brian Higgins. You can't say Brian Albert and bring up all the problems with Brian Albert and, how Brian Higgins was flirting with Karen Reed and, how they were mucking it up or fighting at the bar or whatever. You can't bring any specifics about them in opening statement. I get that. But to say you can't talk about the other reasonably probable circumstances that could have caused these injuries, not mere possibilities. It's not a mere possibility. These are reasonable potential explanations for the injuries to the arm of John O'Keefe. You should absolutely be able to bring that up in opening if you believe that's what the evidence is going to show. And I believe it will. So now they're trying to limit them hammering away at the police investigation, hammering away at the bad cops, hammering away at the expert testimony to say this was way more probably an animal or a fight versus getting hit by a car. Or even a trip and fall, slip and fall in the snow. And then maybe an animal came and bit him later. I don't know. But it was not a car. And so I'm not going to say I'm shocked, but the Commonwealth to continue to try to limit what the defense can provide as their defense is just unconstitutional to me. And it's annoying and it's frustrating. And I just wish they would stop. We heard from Hank Brennan. We want to protect constitutional rights. We want them to have a fair trial. We already know they're going to get into the third-party stuff, but I get it. We can't use their names, but it doesn't mean you can make... Like, if the third-party corporate defense was completely thrown out, they should still be able to say they didn't even walk inside 34 Fairview to ask them questions, to see if they have a dog. They didn't even do it because the investigation sucked. They should be able to make that argument. So we'll see. We'll see what Judge Cannone rules on this. It's also annoying. It's like, yeah, we all agree we can use demonstrative aids in opening, but the defense can't use it the way we know they want to use it. And I think the Commonwealth wants to use a ton of things, and the defense is like, go for it. We know our theory. We know what we're going to present. We're ready to rock and roll. So let me know. What do you think? How do you think this is going to go? How do you think Judge Cannone is going to rule? We have 9 men and 9 women for the jury, which is kind of crazy that they got that even split. And we are rolling into opening statements on Tuesday. What is that going to be? April 22nd, 19th, 20, 21st, 22nd, I think. So April 22nd, this trial is starting. Hank Brennan for the prosecution, Alan Jackson for the defense. Let me know what you're most looking forward to, how you think this trial is going to go compared to the first one. In the comments, hit the like button, subscribe, because the ride starts Tuesday. We're in it. We're all in it. Thanks for being here. Hope everybody has a wonderful Easter weekend. I'll see you Tuesday, Monday. We'll see. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.